travels, once, it used to be twice a month, but since COVID, he didn't go anywhere for 2 years.
Right.
It's been about once a month since.
How are you doing this afternoon? Caleb, very nice to meet you. Jen, I don't know what for, but I heard that
The First District Court of Appeal is now in session. All who have business before this court, draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, in this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have one case on the docket today, Letitia Gradia versus Baptist Hospital. Counsel, if you're ready, you may proceed.
May it please the court. I'd like to reserve 5 minutes for rebuttal.
Okay, so noted.
We are here on a medical malpractice case where the claim is of vicarious liability for the acts of an agent or parent agent. And I'm certain the panel has read the bases for both. And I want to jump in to what I believe is just the controlling law in the First District, which is the Jones case, which stands for the proposition and aligns with both the Second, Fifth, and Third DCAs for the proposition that if a patient does not have a choice in the selection of physicians, it creates an apparent agency issue for a jury to decide. This case is a little bit more extreme even than that, because not only did Ms. Gradia not have a choice in physicians, the initial hospital where she was taken following her cardiac arrest was a level 1 hospital. And
Counsel, is lack of choice alone sufficient to create a jury question?
Under Jones, it is, Your Honor. Yes, sir. But we have more than just that singular lack of choice. We have, as the court's aware, there are also the cases that say it's not the control over the physician, but it's the right to control the physician that also establishes a jury question. In this case, the contract upon which Baptist relies to say that this is an independent contractor is the most...
Very quick, as a threshold matter, do you believe that the apparent and the actual agency analysis, will they rise and fall together, or?
No, Your Honor. I think that you could have an apparent agency without an actual agency.
Can you have actual without apparent?
I believe if
also?
you have actual, then you have apparent. But I don't think...
I see. Okay.
Yeah.
Yes, yes.
And in this case, on the actual agency front and also on the direct control front, the contract under which Baptist is disclaiming responsibility for the physician has it written into the contract that they have the right to control the emergency room physicians. And they've made the argument that that means just the management of the facility. But if you look at that contract, they hire the physician. This third-party company does not have the capacity to hire its own physicians. Baptist has to allow that hire, has to insure that particular physician. They send them through certain credentialing processes. They assign them to committees. What else do they do?
Would all of those things be sufficient without, if the physicians who are at least independent contractors in name had complete discretion over all the medical decision-making and medical procedures done?
I think it would. But in this case, we also have, so the contract is the device we were talking about, but then there's an addendum to the contract that each of these physicians has to sign that says, hey, we will abide by your specific hospital-generated or hospital-supplied guidelines. And the condition that Ms. Gradia presented for, so when the cardiac arrest happened and she went into a coma, the procedure that stops the brain damage is this therapeutic hypothermia protocol. And so they have to chill a patient to a certain temperature, and the guidelines give you to a 0.0 something degree exactly how they're supposed to be chilled to that temperature. They tell you when to take the potassium off, when to put potassium back on, what conditions you have to have beforehand. So this is a guideline that Baptist supplies, and that the physician in this particular case testified that he sought it out and attempted to apply it.
Would it make a difference if the guidelines was the same as the standard of care?
I would love it if we had written standards of care for things.
I mean, essentially, so if a hospital essentially writes in a guideline that you must, apply the correct standard of care for this particular, issue that comes up in the emergency room, would that make a difference?
I think they would have a much stronger argument that is more in the discretion that the physician is trained and empowered to, provide. I think that would be a much stronger argument for them. But where there's a specific protocol, and it's attached as an exhibit, and we've cited to it, I mean, it could not get more detailed and more controlling than that particular protocol. They've made some argument that it's not, that the AHA actually created it. I don't think the record supports that, but at the bottom of it, it says it's Baptist Hospital's protocol, and it is supplied. So I think that's, with all respect, I think that is a sideline. But I want to come back to Judge Osterhaus, your question about the actual agency, because when level 1 physician reached out, they first looked out to see what facility in the area holds themselves out as a level 3 hospital capable of accepting a patient that's going to need this particular protocol. And they identify Baptist Hospital and contact Baptist Hospital, and Baptist Hospital has assigned, and actually contractually in that same document requires their physician to handle these EMTALA transfers. And what a physician in that position has to do is exactly what the physician there did. They said, our facility is capable of accepting this patient. Our facility has the equipment and the personnel, and our facility will provide adequate medical treatment. Those are all things that the clearing hospital has to get affirmance from before they can transfer and ship. And the timeline for when that happened and when the transfer occurred all suggest that those representations that are documented in the medical record were a basis for that transfer.
So would that mean that it would sort of create if we were to accept that, it would sort of create an across-the-board rule for hospitals holding themselves out as, I guess, level 3s or some greater, having some greater capacity to handle emergencies, that once a hospital would do that, then whoever is acting for it, whether it's independent, whether they are an independent physician group or not, that they would be agents once you hold yourself out?
I think it may, Your Honor, but I also think that there are mechanisms at play where they can disavow through consent forms the roles, and they can advise whomever is coming in or whomever has the capacity to sign for a patient when they come in. They certainly allowed Mr. Gradia to sign for the transfer, but they never presented any information to the Gradia family when Ms. Gradia arrived in form of consent form or anything like that. In fact, they write across it that she's unable to sign. So I think there are situations where it could open up a larger liability. I think under the facts of this case, those don't exist. I mean, those don't exist. I mean, he was the actual agent of that hospital for that purpose. And the representations that he obviously made are documented by the transferring facility and signed off on. And in fact, that same form says that Mr. Gradia was made aware of all of those conditions before the transfer and signed relying on those particular components. I think if we just step back and look at how the trial court reached its decision, it never addressed Jones at all. It was clearly argued, it was clearly presented, it's clearly controlling case law under these facts, and there was no attempt to distinguish it at all. I guess the last thing I'd like to bring to the court's attention, there's been some suggestion that all of this, the court's ruling has to be looked at under the new summary judgment standard, but it should not. So the The motions were made and responded to in 2020. By January of 2021, final briefing was done. The hearing upon which the order issued was in March. And then the order issued the day after the Supreme Court's, the new summary judgment law came into effect. The second, and the cite for it, the second, they cited in the brief, but the second opinion, 317 Southern 3rd 72, the Florida Supreme Court specifically says that where the hearing occurs or a rehearing occurs before that May 1st deadline, it should be viewed under the old standard or a reasonable opportunity provided to the non-moving party, both parties actually, to substantiate the record. That didn't occur. Everything was briefed under the old standard, argued under the old standard. The only thing that happened under the new standard was the rendition of the order. I see I'm into my rebuttal time unless there.
Is it your position that this case should have been decided under the old standard or the new standard?
Old standard, Your Honor. Old standard. Briefing was complete at that point.
Thank you, counsel.
May it please the court. Good afternoon. My name is Jenna Wise. I represent Baptist Hospital in Pensacola, Florida, the appellee in this matter. And we are requesting that this court affirm summary judgment on all of the issues of vicarious liability that are before the court today, the actual agency, the apparent agency, and the non-delegable duty. I'll start by distinguishing the Jones case that counsel just mentioned. There are some differences factually between that case and ours. First, in the Jones case, the court notes that it wasn't clear whether the hospital provided a pamphlet that disclaimed the agency of the anesthesiologist to the patient. And we have clear record evidence in the Baptist Hospital's consent that consent was actually provided to Letitia Gradia, although I understand she's unconscious, but that's record evidence that shows that the hospital affirmatively disclaimed the agency of the emergency room physicians. And that evidence was absent in the Jones case.
What is your answer to my question to your colleague about the connection between apparent agency and actual agency? If actual agency is shown through the employment services agreement or the addendum, as he argues, does that sort of cover the apparent agency, or do those rise and fall independently?
I also think that they rise and fall independently. They have separate elements that the plaintiff will have the burden of proving separately at trial. So another distinction between the Jones case and our case is that there is undisputed record evidence in our case that the hospital did not schedule the emergency room providers. That was a responsibility that was delegated via contract to Pensacola emergency physicians, and that's in the record evidence. I have cites if you'd like them, so please let me know.
What do we do with the employment, going to the way that things worked on the ground at Baptist? The employment services agreement, as argued by your colleague, has statements that go to the fact that the physicians group is controlling what's going on day to day, making medical decisions, what have you. But it also has statements that these are under the control of the ultimate control of the hospital. How do we, and of course there's this hypothermia protocol, guideline protocol document also that must be followed. How are we to ferret out where's the line between the control of the hospital versus the day-to-day decision-making that's going on with the physicians?
The hospital only has the ability to control the management. It doesn't control the means and methods by which the emergency providers practice medicine. And that's also clearly stated in the contract between Baptist Hospital and Pensacola Emergency Physicians. And Dr. Petroni testified that he had the ultimate decision-making as far as how he treated his patients. There was nothing that the hospital did to control any of his medical decision-makings.
What about the protocol?
The protocol, and Dr. Petroni's testimony, he was asked about this, and he said it's simply a guideline, and actually appellant has used the word protocol, but Dr. Petroni described it as a guideline. And he said it's available if he needs to use it as a reference or as a tool, but ultimately it's his decision whether to implement that or not. And if you look at the actual hypothermia guideline, it states right at the very top of it that it requires a physician order prior to implementation. So that's not something that the hospital can tell a nurse to start or tell a technologist to start. That's a medical decision-making by the physician to decide whether to implement this hypothermia for the patient.
Are they free to ignore the protocols?
I'm sorry?
Are they free to ignore the protocols? I mean, that's where it gets difficult in the language of the contract. You know, emergency services will be performed and rendered in a competent, efficient, satisfactory manner in accordance with the standards required by the medical staff of the hospital.
Can you let me know what record page you're reading from?
This is 1311. This is just the third page of the emergency services agreement.
Oh, actually, and the one that I have printed starts at 656. So can you tell me what paragraph you're on?
It's B, the third page, 2B. It talks about how services are to be performed.
You're in the disclaimer of agent or employee status, which is number 2, and then B that says PEP shall perform the services required herein according to its own means and methods of work.
That's right.
Which shall be in the exclusive charge and control of PEP?
Yes.
Yes, that is correct. So the hospital does not retain the control for the means and methods of the way that the doctors practice medicine. That is exclusively in the control of Pensacola Emergency Physicians, who is not named as a party in the case.
Well, except to the extent necessary for a hospital to ensure that emergency services are provided at all times in strict accordance with currently approved methods and practices in the field, and that emergency services will be performed and rendered in a competent, efficient, satisfactory manner in accordance with the standards required by the medical staff of the hospital. So, yes, they have this sphere, but it seems to come under the umbrella of the hospital staff.
Well, as to the ultimate outcome, and I think that all of the contract cases that were cited in the briefing are pretty clear, that it's the means and methods that the independent contractors employ that is the critical component for determining whether he's an agent or not. That the ultimate outcome, that the hospital can do things to ensure that that the care is consistent across the board, and they can do surveys to make sure that they're providing the care that they want their personnel to provide. As to the ultimate outcome, but the means and methods by which the doctors practice medicine is up to them. Nobody tells them. Sorry.
Well, then why have the protocol at all? I mean, or even if you want to call it a guideline, why have it at all? Why not just rely on the standard of care, which is in paragraph 16, and obviously controls the practice of these physicians?
So Dr. Petroni addressed this in his testimony, not specifically that exact question, but that this hypothermia guideline is an available tool should he need to reference it. If he doesn't need to look at it, he doesn't have to. It's not that he has to go by that prescribed formula. It's just, if he can't remember what the degrees is that you're supposed to cool a body to, then that's a tool that he can reference if he would like to. But ultimately, it's his choice to evaluate the patient and decide what care to provide, what tests to order, what exams to be completed, what medications to order, and that hypothermia guideline is ultimately his discretion.
What was the hospital's involvement, if any, in the hiring and or selection of the emergency room physicians?
That is also addressed in the emergency services agreement, and that is completely within the control of Pensacola Emergency Physicians. It's their responsibility to vet and contract with the emergency providers, and then Baptist Hospital has all of the emergency providers go through a credentialing process in order to get staff privileges at the hospital. And that's consistent across the board with every hospital that I'm aware of. So back to the distinctions between our facts and the Jones
Yeah,
case.
I was going to ask a question. To what extent was the physician stepping into the shoes of the hospital with respect to EMTALA and having this transfer and blessing the transfer from Santa Rosa Hospital? I mean, it seems like EMTALA is maybe not exclusively, but primarily focused on facilities and the obligations of facilities to take folks, and to the extent that the hospital has given that role to the doctor, and the doctor is making the call. Is the hospital's agents, so to speak?
No, Your Honor, it doesn't. In fact, that was one of the points that I was going to follow up with after Mr. Hall's argument, is that the transfer was actually done in accordance with a statute that he cites in his briefing, which is 395.1041, subsection 3B, and it specifically prescribes how the transfer process works. And one other thing to mention on the transfer is that this is a document that was filled out and completed at Santa Rosa Medical Center. This was not a representation by Baptist Hospital or any purported agent of Baptist Hospital. That document was in the Santa Rosa Medical Center records, not Baptist Hospital's records. So that's not a representation by the hospital. And the prescription for how transfers are to occur is spelled out in the statute.
Well, is it also spelled out in the employment services agreement, where it basically says the physicians group will be making these calls?
In the
on behalf
emergency
of the
services
hospital?
agreement? I'm actually unaware of that. I would need to read that to see if it addresses transfers in the emergency services agreement specifically. I do know that it's addressed in Chapter 395.1041, subsection 3B. So to go back and distinguish the Jones case, there were a few other things that make it different. So the scheduling, that's not a hospital responsibility, that was PEP. So whether there was one provider or 5 providers, that would be a responsibility of Pensacola emergency physicians. That's who I keep referring to as PEP, not the hospital. And that goes to the element of, or the issue about choice in a little bit. The Jones plaintiff also had additional evidence, and the reason that I included the trial court briefing in the record is because it has a lot of facts that were not in this court's opinion when it wrote the opinion that sent the apparent agency claim back to the trial court, when it reversed the summary judgment on apparent agency. But in the trial court briefing, you can see that the Jones plaintiff had additional website evidence that had information about the anesthesiologist, and there was no disclaimer of agency on that website. We don't have any information like that, any evidence like that in our record before us. The Jones case, they also had lots of hospital witnesses that gave testimony in that case, and there has not been a single hospital person that has testified in this case, in our case. One other thing that's pretty big about Jones is that in Jones, the court found ambiguity in the record, and that's the key thing, is that there was ambiguity in the record as to whether it was the patient or the hospital that chose the anesthesiologist. And we know, with undisputed record evidence, that it was Pensacola emergency physicians, not Baptist Hospital, that had the responsibility of scheduling the providers. And there's been no discovery to indicate that there was no lack of choice. Excuse me, that there was a lack of choice. There's been no discovery there's been no schedule. The schedule has not been requested or produced. No testimony related to the availability of any other providers. Dr. Petroni was not asked in his deposition whether he was the only provider on the schedule that night. And then also, this record doesn't have any assumptions made by the Gradias as to the fact of whether or not Dr. Petroni was employed by the hospital. And I know that's subjective, but that is present in a lot of the opinions in the Florida DCAs regarding the apparent agency. When the parties make an assumption that the hospital employed the physician, then that was in Chmielewski, actually, which is the case that said that the elements of reliance and detriment were met when the patient went to the emergency room. But in that particular case, the Chmielewskis chose that emergency room based on its reputation in the community. So we don't have any kind of evidence like that. And finally, I disagree with Mr. Hall on the summary judgment standard. I think that the amendments to the rule state very clearly that the new rule applies to any judgment entered after the date that the rule became effective, and the effective date is May 1st of 2021. Our trial court entered the order on May 3rd of 2021, and in accordance with the new rule, the trial court did actually articulate her findings so that the appellate court would have that information available to them. So therefore, it's our position that summary judgment on apparent agency should be affirmed. And then, excuse me one second. Briefly on the actual agency. So we first need to look to the contract, which states that the parties are independent contractors, and that the parties acted in a manner that was consistent with that emergency services agreement. The hospital did not pay wages to Dr. Petroni. He wasn't covered by workers' comp and didn't have taxes withheld. Baptist Hospital does not bill for the services of the emergency room physicians. And Dr. Petroni testified that he is an independent contractor. So those are all consistent with the contract. And most importantly, Baptist did not retain the right to control the means and methods, and that's in the emergency services agreement at paragraph 2. They didn't tell him what tests to conduct or medications to order or even to implement that protocol, the hypothermia order set. That was a decision that he got to make. And Dr. Petroni, in his testimony, described the guidelines as not hard and fast. So summary judgment on actual agency should also be affirmed. And then I'd like to very quickly touch on non-delegable duty. So this court addressed non-delegable duty in Jones and declined to extend it. The hospital does have a non-delegable duty for its nurses and its technologists, as we know from the Shands versus Juliana case. But this court declined to extend it in Jones. And since Jones, the third DCA addressed the issue in the Tebro case, it's specifically regarding an emergency room, and declined to impose a non-delegable duty on the hospital for the actions of the emergency room physicians. And following that case, Judge Lewis, in an opinion in a transportation case, actually cited Jones and Tebro approvingly on the non-delegable duty issue. And so therefore, summary judgment on non-delegable duty should also be affirmed. If the panel has any questions, I'm happy to answer them.
Thank you, counsel.
This court. Judge Osterhaus, you said, how do we ferret out the line between the right to control, contractual right to control, and the actual control on the ground? I think the jury does that. And I think that there's more than adequate record evidence to suggest that a jury could find that the right to control plus the specific controls that we see on the ground are combined to make enough for a finding of liability. And Your Honor also asked about EMTALA. It's at 657 of the record. There are two things. Judge Rowe, you said, hey, how is that different from the standard of care that they said that they would meet? Well, it's different because they have a specific amendment that they sign that says that they will follow the guidelines of the hospital. A specific agreement that says they'll do that, at the penalty of being fired by Baptist. Judge Lewis, you ask, tell me about this hiring thing, because in the agreement, all that PEP has the ability to do is select a physician. They can't hire them until Baptist says it's okay. They can't hire a physician and bring it into that hospital unless Baptist okays it.
But how far does that principle go? When you talk about control, and when you have any of these kinds of independent contractor relationships, the hospital necessarily has to have a staff privileges, gatekeeping role. So there's always going to be some measure of control. If that were the only thing that were present, the credentialing and the staff privileges, would you still say that that creates a jury issue?
I think if the contract says that I have an exclusive right to control, they have a problem. As soon as they put that language in, I think we have a jury question issue. But this contract goes way beyond that, because if they fire one of these physicians, there's a non-compete that goes around the perimeter of Baptist, not for PEP. PEP can still do what PEP needs to do, but the hammer for control that exists here and gets exercised is significant. It's the right to control that should govern this decision. And the right to control, I've never seen it this broadly. There's another hospital in this, and they don't have an exclusive right to control written into their contracts. I've never seen it this hospital-sided, I guess is the way I would phrase it. But back to 657 of the record, Your Honor, they have a specific requirement to follow EMTALA, and in fact, PEP has an obligation to indemnify Baptist for any liability that's found because of that. So in this situation, you're not opening up some new level of exposure for Baptist that Baptist hasn't already contracted away. So that's, in this case, it wouldn't be a concern. And I was concerned about one of the things that opposing counsel said, and it's in regard to that EMTALA form. And the suggestion, I think, was that, well, that's Santa Rosa's documentation, it's Santa Rosa's record. I don't think they're suggesting, though, that Dr. Petroni didn't tell them these things as they were contemporaneously documented on Santa Rosa's records. When I asked Dr. Petroni in his deposition, did he have the form that he signed? And he said, no, but I would have signed it. I said, did you have that conversation with him? Yes, that's how this occurs. So I don't think, and I don't believe she meant to imply that those representations that were made to Santa Rosa came from anywhere else or were taken out of thin air. I mean, the agent for the transfer was Dr. Petroni for the facility, and that's where that information came from and was documented. And it's documented at certain times. So the telephone call happens, they check a box, they learn this new information, they check a box, they have the conversation with Mr. Gradia, they check a box, and he signs, and all of that has a timestamp on it. So all of that is a contemporaneous representation of the actual agency that this level 3 exhibited to receive this patient. And it's improper for them to disclaim any responsibility for that agent now that everything went sideways when the guidelines weren't followed. Summary judgment should be reversed and denied. Thank you.
Thank you, counsel. Thank you both. This court will stand in recess.
All rise.